Hello and welcome to If It Pleases the Court, an insider look at Compassionate Choices legal docket and courtroom updates, including the U.S. Supreme Court. I'm Patrick Donges, Digital Advocacy Director of Compassionate Choices, which of course is the nation's oldest, largest, and most active nonprofit dedicated to improving care, expanding options, and empowering everyone to chart their end-of-life journey. Before I introduce our panel and our moderator, I appreciate your attention to just a few details that will help you get the most out of our program today. Live captioning, including translated captions in Spanish and a variety of additional languages, is available at this program by selecting the closed captioning. That's the double C icon, CC icon in Zoom. There will be 10 minutes for questions and answers toward the end of this program. You may type your questions at any time by selecting the Q&A icon in Zoom. Our panel will answer as many questions as our time allows, and we will only be taking questions from the Q&A function. So there's no need to raise your hand or type questions into the chat box. And lastly, this webinar is being recorded, as you likely heard at the top of the program, and will be sent via email to all registrants. Now I'm happy to welcome our expert panel. We have with us Kathy Sermenia, JD, Professor Emeritus at NSU Florida Shepherd Broad College of Law and co-author of The Right to Die, The Law of End of Life. Jon B. Eisenberg, JD, with counsel in the Terri Schiavo case and is an appellate law expert. And Veronica Darling, JD, is Director of Litigation at Compassionate Choices, working on cases affecting end-of-life care access across the country. And finally, I'm extremely happy to introduce our moderator, Compassionate Choices Interim President and CEO, Chief Legal Advocacy Officer, and General Counsel, Kevin Díaz. Kevin?
Thank you, Patrick. It's really exciting to be here with all of you today. We have a lot to cover, so we're just going to go ahead and jump right in. First of all, I just want to ask the question, what are some of the current legal barriers that people are facing when they try to assert their end-of-life wishes? What are you seeing out there? Veronica?
Thank you, Kevin. The thing that I'm seeing the most, that comes in most frequently, are people who report their do not resuscitate or do not intubate orders are being honored, particularly in what physicians consider non-life-threatening scenarios, where there's a regular procedure, a regular day, and essentially the staff on hand wasn't prepared to have to deal with a DNR or a DNI at that time.
And so when you hear about those things, do they usually come in a certain fact pattern, or how do you hear about those cases?
We get a lot of calls and emails from supporters and concerned family across the country, really from every state. And it depends on the general facts, but they're usually the same. An elderly person is admitted to the hospital for a routine procedure, an endoscopy, a hip surgery, something that is considered relatively routine. And at some point in the course of their treatment, they suffer respiratory arrest, cardiac arrest, something to that effect. And rather than consult an advance directive or the family, the hospital jumps into immediately applying all life-saving and resuscitation measures that it turns out are actually contrary to what the patient wanted. And so we get contacted by the families asking if there's anything they can do. Sometimes the patient has already passed. In some cases, the patients live another couple years in pretty serious pain because of the nature of the resuscitation.
So when that happens, I guess I'd open this up to the rest of the panel. Is there some sort of legal justification that the healthcare institutions have for not honoring that directive from the patient, or why would they do that? And what can people do to try to avoid that situation?
Well, I do know that one legal justification that has been offered was that we had presumed that the person who was undergoing surgery, they fully intended to complete the surgery and was, and then to live on thereafter, so that this was not a situation in which the DNR, DNI was intended to apply.
Right. So when thinking about recent court cases that have been coming down or decisions, has that changed or restricted access to end-of-life options recently? And I'm thinking here of options like palliative sedation, voluntarily stopping eating and drinking, or medical aid in dying.
Well,
Jon, go ahead.
I would say, obviously, Dobbs is of concern to all of us because the legal underpinning for the right to reproductive care is the same as the legal underpinning for the right to die, which is the right of personal autonomy. With Dobbs doing what it did, kind of halfway getting rid of the notion of autonomy in reproductive care. I say halfway because the other half is the notion of autonomy in end-of-life decision-making. And it seems almost inevitable that that issue is going to end up before the Supreme Court again, although I don't think there will be much of a difference in how they treat end-of-life decision-making, specifically removal of artificial nutrition and hydration. So Dobbs is concerning. I'm not sure it threatens the right to refuse medical care. I think it very much threatens the right to medical aid in dying, which we will be getting into in a few minutes. There is good news from the Oklahoma Supreme Court last year in a case called Guardianship of LAC. Those are the initials of the patient. This was a nonverbal patient with a terminal illness who had an advance directive against artificial nutrition and hydration. And her guardian ad litem testified in the trial court that when the patient was told, or at least words were spoken to the patient saying, if we remove your feeding tube, you will suffer pain and suffering as you die. According to the guardian ad litem, the person's eyes got wide and they looked fearful, and the guardian ad litem took this as an indication that she wished to revoke her advance directive. The Oklahoma Supreme Court said that for revocation of an advance directive, clear and convincing evidence of intent to revocate will be required, and the look in one's eyes just didn't cut it. And so that's the first case nationwide that has spoken as to the requisite degree of proof for revoking an advance directive, and it's quite favorable. I think it signifies a trend nationwide. It's good news.
Yeah, that is good news. Going back to Dobbs, which you touched on a little bit, I wanted to hear from Kathy if you thought that the Dobbs decision had any significance or effect on decisions like Glucksberg or Cruzan.
Well,
and maybe take a second to just talk about what those cases stood for or mean to end-of-life care.
absolutely. So the first response to your question is that, of course, a Supreme Court precedent in the area of medical decision-making is going to have an effect on end-of-life decision-making as a part of medical decision-making. The cases that you refer to, Kevin, are Cruzan, the case of Nancy Cruzan from the state of Missouri, in which the U.S. Supreme Court considered an appeal of cert with review of the wishes of the parents of a young woman who they said would want to refuse artificially supplied nutrition and hydration. She had not had a written advance directive, and the question was whether Missouri could require a high level of proof to determine whether the parents' allegations were accurate. The U.S. Supreme Court said Missouri could require a high level of proof. It was not a violation of due process to do that. However, it had great supportive language throughout, detailing a history of this right that Jon mentioned, personal liberty, bodily autonomy, detailing that even under the common law, leaving aside the Constitution, there was a right to say no a right to tell people not to invade your personal space and especially not to invade your body with, for example, feeding tubes. Unfortunately, the court stopped short of technically saying that there was a constitutional right to say no to bodily invasion through medical treatment. It assumed that that right existed. Followed up a few years later, about 7 years later, by the cases of Glucksberg and Quill, in which the question was whether state laws that prohibited aid in dying, what we now call aid in dying, as assisted suicide, were constitutional. And the Supreme Court there indicated a definite line, and this is the line that Jon was referring to, I believe, right? A line between the right to say no and thus allow refusal, withholding, withdrawing of medical treatment versus the right to decide how and when to die. And the Supreme Court said rather clearly in that case that the justices at that time did not believe that that was a constitutional right and did not find historical support in it, which is important in the constitutional decision-making realm. So, unfortunately, right, we don't have a technical holding on the first, but I think that I agree with Jon, it's safe, right? The only question may be nutrition and hydration in the artificial form versus nutrition and hydration in a more natural form, which I know we intend to talk about. Medical aid in dying under those cases is a non-starter.
Yeah, so I want to go into that a little bit more. So obviously with the changes in the U.S. Supreme Court that led to the Dobbs decision, I'm curious what you all think the significance of U.S. Supreme Court Justice Neil Gorsuch's views on end-of-life care and medical aid in dying specifically. What is that significance given that he is now on the court and he has written pretty extensively on the issue?
The significance of Gorsuch is that he's written an entire book on medical aid in dying, although he titled it The Future of Assisted Suicide and Euthanasia, which gives you a sense right off the bat where he stands on medical aid in dying. He's against it. The Glucksberg and Quill cases just said there's no constitutional right to it. They didn't address the issue whether medical aid in dying is unconstitutional. Gorsuch's book advances an argument that that medical aid in dying is an unconstitutional denial of equal protection because it fails to protect vulnerable individuals who may be subject to coercion, abuse, or mistake. Gorsuch calls this a, in quotes, inviolability of life principle, which involves two elements. First, the intentional taking of human life by private persons is always wrong. That's a direct quote from his book. And secondly, that medical aid in dying statutes perpetuate inequity by creating a second class of citizens who are at risk of being, quoting again, killed without their consent due to abuse, mistake, or coercion. Now, what he says is that the element of intent is essential to his doctrine of the inviolability of life. It distinguishes medical aid in dying from the right to refuse medical treatment. He says that a physician following an advance directive to withhold medical treatment doesn't intend to kill. And that's why I say I think the right to refuse medical treatment is safe. But Gorsuch says the physician providing aid in dying does intend to kill by assisting the patient to end his or her life. This issue will eventually get to the U.S. Supreme Court. There are efforts already to get it there. When it does, it's a sure bet, I think, that Justices Thomas and Alito will vote with Gorsuch. Probably also Amy Coney Barrett, although she's proving to be a bit of a wild card. On this issue, I don't think she will be. That leaves Roberts and Kavanaugh as likely swing votes. And I think when the issue gets to the Supreme Court in whatever case, and compassion and dying is there on the battlefield filing an amicus brief, it's going to be important to somehow appeal to Kavanaugh and Roberts, who, for better or for worse, are currently our moderates, our swing votes on the court. I would argue that people frequently obtain medical aid dime prescriptions without ever intending to use them. They get peace of mind from knowing it's there if their suffering becomes unbearable. Frequently, the prescription is filled but never used. I think an argument can be made that the physician who prescribes it doesn't necessarily intend to kill or assist in killing. The primary intent is to provide the peace of mind of having the prescription available just in case. And I know of and personally know people who have got the prescription, never took it, but they felt better knowing it was available. That element of intent that Gorsuch insists is critical to medical aid in dying, I think is not there. Secondly, I think it will be important in the coming years to develop empirical data showing that the idea of it being subject to coercion, abuse, or mistake is not supported by the data. That's something that needs to be worked up. But in any case, we need to be prepared for this coming. This issue will get there.
So one of the pieces of data that is already out there that I think supports some of the things that you were saying is the fact that almost a third of the people who receive a prescription ultimately don't use it. And I think that's something that distinguishes what happens, for example, in the United States versus many other jurisdictions, especially foreign jurisdictions. Yeah, I mean, that's a really good point. Why does it, besides the fact that Gorsuch focuses on it so much, what are some of the other reasons that intent matters so much when we're talking about end-of-life care?
You have to ask a bioethicist, and we have one with us. What do you think?
Well, I'm presuming I'm the bioethicist.
You are.
Intent is crucial. Without commenting on Justice Gorsuch's views on intent, I can say that if you look, for example, at the withholding and withdrawing treatment, right from the very beginning, so many of the arguments that were raised were about, but this is going to result in death. And the key argument in response was death is not our intent, peace, right? Getting rid of bodily intrusion, avoiding pain, all of these things, more comfortable death is the intent, even though we might foreseeably see that death will result. So we have a couple different forms of, right? Do we foresee something versus is that really what we want to have happen, intend to have happen? One place that it matters a great deal, for example, is with the doctrine of double effect and terminal sedation, which was praised enthusiastically by the judges in the justices in Cruzan. In fact, one of the pillars of their discussion really was an assumption that terminal sedation, which is receiving enough pain medication to not be conscious or to be minimally conscious so that your pain will be relieved and a patient wouldn't have to undergo pain. And then refusing artificial nutrition and hydration until the person passes away from dehydration and lack of nutrition. The idea there is that we need enough medication to kill the pain. And there was always concern, understandably, on the part of physicians that if I give too much pain medication, which I can foresee might might kill someone because it depresses respiration, then I will be brought up on charges, for example. And the doctrine of double effect essentially says that if you are intending to relieve the pain, right, you are all right in terms of intent, right? You may know that you're treading on, death, and you may be relieving this person's pain, putting them into a condition in which they cannot accept food and water orally. And that would mean they would have to rely on artificial nutrition and hydration, which they are refusing. And thus you can foresee that there will be death in the future. But it's the intent of wanting to relieve their pain that matters, and that's perfectly fine and an acceptable way to approach end-of-life care.
Given what you just said, would you suggest to supporters that, especially if they're living in a state where medical aid in dying isn't authorized, that perhaps when they are confronting great amount of pain, that they really stress the fact that they want as much pain medication to alleviate the pain versus asking for something that maybe isn't available in their jurisdiction?
I absolutely would. My own advance directive, it says, comes just short of saying, pump me full of pain medication. I really don't want to be in pain.
Right. I think most people aren't terribly concerned about issues related to any sort of addiction or things like that when they're at the end of life. It's really not an issue. So speaking of pain medication, that also raises questions about other end-of-life issues and the access to them. And I'm thinking here of freedom of speech or freedom of religion issues and how that might apply to end-of-life care. Veronica, do you want to talk a little bit about that? You're on mute.
Knew I was going to do that. Absolutely. I'm happy to talk about this. The First Amendment issue that we anticipate coming up in the context of end-of-life care is something that we're seeing in states that border states that have severely restricted abortion care. And one thing that's happening in those states is you have a state like Idaho that has almost a complete ban next to states like Washington and Oregon that have very liberal abortion access laws. And so there are groups, nonprofits, that work to advertise abortion care in Idaho and how to obtain it in Washington or Oregon, and groups that work to get patients, women who need abortion care, to Washington or Oregon. And those cases there have been challenges to Idaho laws and laws in Tennessee that restrict how much someone can say in Idaho to allow someone what they need to access care in Washington or Oregon. That's applicable to end of life cases because we now have two states, Oregon and Vermont, that do not have residency restrictions. And so we have patients who reside outside Oregon and Vermont who are able to make their way to those states to access legal medical care in the form of the end of life option. And there is a possibility in those states when their family returns to their state of residence being charged with some form of murder for assisting someone to get to another state. And there are issues of chilling speech under the First Amendment for doctors, hospice care workers, end-of-life counselors, and social workers in states that do not have medical aid in dying for discussing the end-of-life options available in Oregon and Vermont with their patients. And that's extremely concerning.
So, but wouldn't the requirement of obtaining informed consent from those patients trump any sort of prohibition of being able to share truthful information about an available medical procedure in another jurisdiction?
It should, but there aren't distinctions like that in the laws that we're seeing. Specifically in Minnesota, there's a prohibition on assisting another in taking their own life, and that has been interpreted in prior cases as speech. The act of talking to someone about suicide and expressing individual targeted encouragement of suicide has been held to be a violation of the assisted suicide prohibition in Minnesota. And it was done in a straight criminal case. We were not talking about aid in dying, but when you apply that to the various end of life counselors, hospice workers, and medical care providers we have in Minnesota, they would run afoul of the statute and be committing a felony by talking to a patient about how to access care in another state for the purpose of ending their life.
The for, we've heard a little bit about how in certain states end of life options are constrained. I'm curious, how do we see state constitutions protecting access to end of life care as opposed to, say, the federal constitution?
That's a big silver lining, actually. States often have far more protective constitutions for privacy, speech, and medical, in some cases, specific medical rights than the federal constitution does. So we're seeing states or medical providers and litigants and healthcare advocates use really protective state constitutions, like the Bill of Rights in the state constitution of Montana, to preserve the right to access healthcare and have private conversations with your doctor in the state of Montana that the government can't restrain or restrict.
That's really interesting.
Kevin, can I ask, this is Mickey from Compassionate Choices, and I just wanted to share with folks, we're having kind of a robust chat about expanding medical aid in dying across the country so that people don't have to change directions. And I just wanted to point out, I've heard from our team on the ground, our campaign on the ground in Delaware, that the Senate just passed the Ron Silviero and Heather Block End of Life Options Act in Delaware, which means it's successfully passed both chambers and headed to a governor for signature who, while we can't promise anything, did campaign on this issue when he was being elected governor. So I'd like to see that smile on your face and hopefully the smile on the face of Delawareans in the hope that medical aid in dying will be available there shortly. Back to you, Kevin.
Thank you. That's great news. We've been on pins and needles all morning. So you mentioned a few things there, Veronica. What else can supporters do now to prepare and protect for their access to end-of-life options?
I think the most important thing is talk to your friends and family. Talk to the people who support you, talk to your doctors, and talk to them early. It's really difficult to have conversations about advanced care planning and what you want when you're in a health crisis and when you're in crisis mode. It's far easier to have these conversations when everyone is doing well and feeling good, and having the people around you know what you want is very important to let them be able to advocate for you when you are in a position where you're incapacitated or a doctor is questioning whether or not a DNR or DNI applies. And it's important for them to know that information and have it backed up in a recent enforceable advance directive document and know what your rights are. Know going in, talk to your doctor when you have a routine procedure and ask them what those issues are, what their procedures are if someone has a serious medical event during a routine procedure. Not that you're anticipating it, but open that conversation up and get to know your state laws, get to know your state constitution, talk to your legislators. When legislators hear from you, it makes a difference. Montana just defeated a physician criminalization bill because so many people reached out to their legislators directly and told them their stories. They told them why they needed medical aid in dying to stay available. And we had the victory that we had in Montana because those people reached out and told their individual stories. It's incredibly important, just as important as documenting your wishes, making sure as many people know about them as possible.
And another point about the Montana victory was that 16 Republicans crossed the aisle. It was a bipartisan effort. And we really do view our issue as a bipartisan one because everyone is going to have to face these really difficult decisions at some point in their life. So Thank you for that. And then, of course, as we just heard from Delaware and we've heard in the past from other jurisdictions, we can effectuate change if we make sure that our wishes are known. And the polls over and over and over again say that the vast majority of people are in support of having some control over their end-of-life medical care. And so I think with all of the support that's out there, one of the things is it's just a matter of harnessing that and making sure that the people who are making the decisions hear about what people want and that we hold them accountable to those
Kevin.
desires. Yes.
So, Kevin, just to reiterate, pick up on something you just said and something that Veronica had said. I wanted to emphasize to all of the Compassion and Choices supporters out there that advanced directives are, remember, both written instructions and designation of a trusted person to advocate for you. And what looks on paper to be very plain can be totally misunderstood in context in a different situation than everyone was thinking of when that statement was drafted. So that really the most important thing, there's a bioethicist from the very early days of this movement who always said that the absolute most important thing was to name someone that you trust and that you have discussed your wishes with to speak for you and to advocate you at that time for you at that time, because interpretive questions will arise.
Yeah.
I'll add
go ahead.
Also, it's important to appoint somebody who you are confident will have the emotional wherewithal to carry out your wishes, which might be difficult for some. So make sure to speak with them and make sure they're comfortable with doing what you would like them to do.
Yeah, and I'll also add, to the extent that you can have a relationship with your primary care provider or whoever it is that is providing your medical care towards the end of life, that's also really critical so that they understand what your goals are, what's important to you. Do you want to live as long as possible, or do you want to live in maximum comfort? Do you want to be going through rehabilitation in the last two weeks of your life because you had some major procedure? I mean, I think all of those things really are critical to getting what you actually want. Unfortunately, we're running a little bit short on time, and we do want to make sure that we allow time for questions. So feel free to go to our website and look at some of the great legal work that's going on. One of the cases, or one of the efforts that Jon described about trying to bring a case forward to challenge the End-of-Life Option Act in California using the Gorsuch roadmap, is something that we're involved with, and you can go to the website and read about it a little bit more. That's the United Spinal case. But for now, I wanted to thank all of our panelists for this robust discussion, and I hope the participants will stick around for our upcoming Q&A. Is the oldest, largest, and most active organization working on end-of-life care policy, Compassion and Choices is uniquely positioned as a resource for consumers and legal professionals seeking ways to support the patient-directed end-of-life care movement. And with that in mind, I am proud to announce the foundational future of our legal service advocacy efforts. We're calling it Compassion Legal, the End-of-Life Justice Center at Compassion and Choices. To tell us more about this center, I'm happy to welcome Compassion and Choices Chief Strategy and Marketing Officer back, Mickey MacIntyre, and welcome back to our Director of Litigation, Veronica Darling.
Thanks very much, Kevin. We're super excited about this. We're also going to try and talk a little bit about some of the cases that are currently on the docket for Compassion and Choices. But we're thrilled with the creation of Compassion Legal, the End-of-Life Justice Center at Compassion and Choices. We call it Compassion Legal for short now, and it's the next iteration of the legal powerhouse behind the fight for autonomy, dignity, and justice at life's end that we have all known and loved. And I was just chatting with Margot in the chat reminding folks that the reason why Montana has medical aid in dying is from a court case that Compassionate Choices filed on behalf of some Montanans nearly 10 years ago, I think, or 15 years ago at this point, that was just defended. Compassionate Choice has been on the front line of legal defense for patient-directed care, demanding systems that respect personal choice, informed decision-making, and access the full range of end-of-life options. We have 6 now staff attorneys and a wide-reaching network of firms and attorneys partners that take on, like the institutions that we're talking about. People were saying, how do I get accountability around my DNR? Part of that is that we've had to file lawsuits for folks around it. And we're going to continue to take on those interests that want to take away your right or not recognize it in order to get your rights enforced. Right now, we're engaged in about 19 active cases and monitoring an additional 54 cases across the country for potential issues and impact and potential engagement. From medical aid and dying to advanced directives, the fight we fight to make sure that your medical chart reflects your choices and that you're getting the care that you want, that follows your plan and your end-of-life journey. We're doing this for a variety of reasons, but we're going to cut to the chase. We're kind of getting this center organized in order to increase the number of cases that we can bring, increase the exposure of the work so that it can help change the medical establishment, the healthcare environment, systematically as well as systemically in bringing forward what it is folks want. In order to do that, we need more people to let us know about the issues that are impacting them in their care so that we can potentially see if there's a legal action that could be taken. And we need more attorneys and firms to join us at our legal network. So we've divided the work into basically 3 different project areas. And we're going to cover those 3 areas. And Veronica's going to let us know a little bit about the cases that we have going in some of those cases and those projects. The first project is the Patient Rights and Freedoms Justice Project. And this is about your decisions being honored and fulfilled, ensuring that fully informed patients, you, are the decision makers for your own end-of-life care, and that your decisions and plans are implemented. Hey, Veronica, tell me a little bit about what you're thinking in this project and the work that's happening.
Yeah, when I think about these cases, I think of the things we've spoken about previously, cases where a DNR or a DNI was violated. We've also taken on cases where disposition of remains was not done properly and where the state is contesting whether or not they had to give remains to the person identified by the decedent. So those are important cases. We've got cases in Illinois pending on the DNR, DNI issue, and a couple others we're queuing up. But that's what we think about when we think about these freedoms.
Great. Is there one in particular that kind of strikes you, or?
The case that I think about the most that keeps me up at night is in Illinois. There's a litigation pending where a gentleman had a DNR in place. I believe he was on hospice care and was transported to the hospital for a UTI treatment. And while he was in the hospital getting treatment for the UTI, he suffered cardiac arrest and experienced severe and violent CPR to resuscitate him in addition to intubation, contrary to his DNR wishes, and ended up living another 563 days in pretty excruciating pain from having various broken ribs and a cracked sternum that weren't able to heal. His family is currently working with an attorney in Illinois to hold the hospital accountable for not honoring his DNR.
Thanks. Veronica, there's been some talk at the top of the hour, as well as some questions about, could you speak for a second about just factually about the immunities for emergency personnel when it comes to honoring DNRs?
Sure.
Could you address that for a second?
In the case of, there's several different personnel involved in those decisions. There's usually a statute in place in most states that give immunity to specifically EMTs and paramedics who arrive on the scene and wouldn't necessarily know what someone's wishes are. In the case of hospice and palliative care and long-term care facilities, it is should be harder for those individuals and medical providers to have some sort of immunity from liability because they have awareness of the advanced directive of the DNI and DNR. In the cases that we work on and work to try and get in front of a judge, we are looking at who had knowledge of the DNR, DNI. Was it in the medical file? Did the family bring it? Did they talk to the doctor about it? Because we have to establish there was knowledge there and a discussion and some sort of understanding in order for the hospital not to be able to say, how can we honor something we didn't know about? And I think that some people don't connect as frequently as is necessary to have that conversation, make sure that document's in the chart, make sure the hospital knows about it, make sure your care facility knows about it.
Right. I also just want you to address one more thing on this because it'll take care of some of our Q&A
Sure.
in the end. DNR tattoos, DNR bracelets. Take it away. Go for it.
I think Kevin actually might have some stories about DNR tattoos. In most cases, you're going to have to use the state document. In addition, I would say if you have a DNR tattoo, I'm hoping that you have an advanced directive filled out that's pretty clear and pretty intent. But the thing is, you can revoke a DNR orally in most states. You can revoke an advanced directive orally in most states. And so what you say, despite having a DNR tattoo on your chest, some medical professionals could say, but he told me right before he wanted the CPR. He wanted an intubation. I asked. So DNR tattoos, not as legally solid, I think, as having the documents in place and discussions with your friends and family to make sure they're there to advocate for you. And they know they're not just going to have to say yes or no. They're going to have to really stand up and get loud.
Right. And that DNR tattoo can be trumped by your proxy, right? Like if they're not fully vetted and on board with what it is you want. Kevin, are you trying to get in there?
I was just going to say, though, if for people that have gotten DNR tattoos, it certainly puts the care provider on notice.
On notice.
I noticed, yes.
Like they can't say, well, I had no idea that they had a document, or I didn't bother to ask that question. So in that sense,
Yes.
you think of
It
what
does make
takes to
them
get a
ask.
tattoo. Yeah, exactly.
Yeah.
Great. So we're going to press on. Thank you very much for that because there was a little chat in that. We're going to move on to the second project, which is one that I know interests a lot of the people who are on our call today, which is the End of Life Options Access Project. And this is divided into two areas. One is the Medical Aid and Dying Initiative. This is about your options, protected and expanded. So this is about getting medical aid and dying for more people across the country. And then End of Life Options Protection Initiative, this is really about some of what Kathy was talking about, which is protecting the existing end of life options from being diluted or overturned or whatever it might be. What are you thinking about in terms of what this means to the work? And do you have a couple of examples of what this current cases that we're working on?
Sure. We've actually been able to resolve a couple cases recently in this area without having to resort to litigation, which is extremely important and something that doesn't necessarily get reflected in our numbers is how often we have people call. We enter into an engagement relationship with them and we just start making calls. We start writing letters and we can get things sorted out rather quickly. We had a woman in California call us and tell us that her aunt had moved into a private board and care facility. And after she moved in, was approved for medical aid and dying. They chose a private board and care facility because they understood she couldn't ingest medical aid and dying medication in a hospital or in a more high-level skilled nursing facility. And when the staff heard her on the call with her pharmacy, doing her consult for her medication, the staff became very upset. They tried to convince her not to use medical aid in dying, asked her if she knew what she was doing, and told her that under no circumstances in the state of California was she allowed to ingest medical aid in dying medication at a private board and care facility. So she went to her aunt's house. She used the medication. She died peacefully and exactly how she wanted to die. And the next day, the private board and care facility gave her niece a bill for the next 30 days of board and care because she had not given a 30-day notice to vacate the premises. And they argued that medical aid in dying was not a natural death, so it didn't waive her obligation to give notice. And we resolved it in 48 hours by explaining the law. And we've had similar cases involving people who want pacemakers turned off, and a doctor refuses, and a doctor says, no, we can't do that, you'd die. We get on the phone, we make calls, we write letters, and show them that these patients have representation, and we're able to help them.
Great. Thanks. We're going to turn our attention to the last project area before we go to Q&A. But thank you. We're covering some of the Q&A along the way. This one is really kind of about the systemic change of medicine and healthcare practice to be more patient-directed, more patient-centered. I love the name of this one, the Healthcare Improvement and Accountability Project. And this is Your Care Transformed and Secured. What you got for me in this one, Veronica?
Well, we have a current case pending before the court in Oregon where we submitted an amicus brief in support of a statutory structure here that reviews hospital mergers and specifically asked the court to keep the statutory scheme in place, to continue enforcing it, because here in Oregon, we have a lot of religiously based hospitals merging with non-religious hospitals, and there is a risk that some forms of care might be deprived in those situations, or a specialty facility merging with a non-specialty facility. And we want Oregon to keep the laws in place that make sure care is not being negatively impacted when facilities merge together. So making sure no one's lost in the capitalist shuffle of hospitals.
This is like so super important now with the mergers and the acquisitions and the consolidation of health systems, particularly community hospitals in rural environments where there may be a monopoly of care now, or university hospitals being consolidated with for-profit entities, and just the total consolidation of medicine and medical practices and doctors' practices into health systems in this new model of healthcare delivery. So thank you very much for that. So like, what can folks do? You want to talk a little bit about like folks contacting us?
Yes, absolutely. So we have a legal helpline. It's 1-800-247-7421. There's also a legal intake form that you can access through our website, and I think Mickey will probably have that available for people who've attended this session. But essentially, if you have something, you or your family member, your friend, is having difficulty accessing end-of-life care, getting what you want in your end-of-life care, having medical providers respect those choices, submit a form, give us a call. We'll evaluate the situation. If you're already working with a lawyer, we're going to need permission from that lawyer to be able to speak with you. We aren't going to be able to help you with wills, trusts, or estate planning, but we'll be able to direct you to your bar association. And just calling doesn't make you a client, but it does allow us to review the facts of your case, to talk to you more about what's going on. And if it is something where we think we can help you by getting pro bono counsel attached, local counsel attached, then we'll go through our conflict check process that we have to do as lawyers and our formal engagement letter and move on from there. But the way to change healthcare in America is to get people involved. And one of the ways you can do that is give us a call if you think there's something going on that's impeding your access to end-of-life care.
Great. And I just want to add, we have some providers, we have some doctors and clinicians in that chat that I've noticed. And so like, if you're struggling to provide high quality end-of-life care, we want to hear from you too. It's not just folks trying to access, it's people who are trying to provide.
Yes.
So
physicians especially are great.
Yeah, we represent doctors, we represent nurses, we've represented everybody. So do that. And then if they're a lawyer, do we want some additional lawyers helping us out here, Veronica, you think?
I
This is
always want more lawyers on board. If you are willing to come in and do the work and help out our clients, we need lawyers all over the country in various jurisdictions because we're not licensed in every single jurisdiction. And so we like to partner with pro bono counsel in states all over the country who can really get in and know the local area and help us get these cases resolved and in front of judges and get some publicity so that people know this is going on.
great. And we have like O'Melveny and Myers and
We
Hogan and
do.
Lavelle.
We've the In the last year, I just checked before this meeting, we've worked with O'Melveny Myers, Hogan Lovells, Wilmer Hale, Latham Watkins, and Perkins Coie as the big firms. And a lot of times we partner, if you are a smaller solo practitioner, we partner with big firms and smaller local counsel on the same cases. Um, Everybody chips in, gets the work done, so we can get these things resolved.
Great, great. Thank you so much, Veronica. Hey, Patrick, I'm going to turn it back over to you for maybe one or two questions. We did get some of them covered already, but take it away.
Sure. We have a question right at the top from Thanos. Is there any document I can prepare today to explicitly define that I want medical aid in dying when I can no longer function on my own? I have an advance directive, a last will, and a 5 wishes document in California. My family knows about my desires, but I'm not sure if they would be able to legally follow my instructions. Are there quantitative measurements of dementia that I can specify to trigger death with dignity? So that is specific. There's been a couple of questions about dementia in the chat and Q&A. So that's specific to dementia.
So right now, medical aid in dying isn't available if people don't have the capacity to make a decision, a medical decision. And so I don't know that you would be able to access medical aid in dying. But one of the things, or one of the several things that we really encourage people to do in an advance directive if they're suffering from dementia or have been diagnosed with dementia and are early in those stages is to be very explicit about the kinds of routine medical interventions that may take place without second thought from your medical provider, that actually, if they were, if you can successfully decline them or if they're not administered to you, will likely lead to a relatively peaceful death. So here we're talking about antibiotics for urinary tract infections or pneumonia. Another thing is to specify kind of what level of care you would want. So, not only say you do not want artificial nutrition and hydration, but maybe also specify that you want comfort feeding only. In other words, you aren't necessarily interested in prolonging longevity because of nutritional or calorie intake, but you certainly don't want to suffer. And it's a kind of a common aging circumstance where you desire less food and you're less interested in food. That can also lead to a shorter period of suffering with dementia. And
I'm
also,
go ahead.
Oh, go ahead. And I was just going to say one last thing. And just saying the normal kinds of things that, Kathy had referred to earlier, any sort of suffering, pain, like tons of anxiety or agitation, opt for having the most meds that you can get so that you're not having to suffer through those circumstances, if that's what you want.
I went ahead and posted the, sorry, go ahead, Mickey.
I was just going to say, Patrick just put the dementia values and priorities tool in the chat for folks to use in that situation as well.
Oh, great.
Thanks.
I think we have time for one more question here. This is from Roger, who recently had cataract surgery. And he said, when I arrived for surgery, I was given a form to sign suspending all advanced directives, DNR, DNI, etc. I believe this is a way to protect the statistics of institutions. Is there a way to fight this requirement going forward?
Veronica, do you want to handle that one? It seems like a common fact pattern you've had.
It is a common fact pattern. It's something that we're working on internally, and we are aware this is, I think the most recent one, we had a woman tell us that to get dental care, she was asked to waive her advance directive. And I mean, the short answer is if you call us, the more people we hear from, the more cases we have like this coming in where someone wants to say, no, I'm not waiving my advance directive to get this medical care. The more we can do something about it. It's a really interesting area of law that I think insurance companies have put in place for doctors, but hasn't been really challenged. I would like to know what your doctor says if you refuse to sign it and say I have a DNR in place for a reason. Um, I don't know of anyone who's actually said that in the context of like a cataract surgery or an endoscopy or something where it needs to be done diagnostically to treat you. Um, but you want to keep your advance directive in place. Call me. I'd love to talk about it.
Well,
800-247-7421. Call Compassion Legal Helpline. Veronica standing by to take your call.
thank you so much, Mickey. Thank you, Kevin. Thank you to our panelists today. We are just about out of time. And again, if you are struggling to get the care you want or you're facing challenges in providing care, it's 800-247-7421. Also, if you're an attorney willing to provide pro bono legal services, please leave your information and we'll be in touch. On that note, Compassionate Choices depends on individual donations from people like you. Every dollar raised supports our mission. You can donate right now by clicking the link that just went in the chat at cnc.link/legalwebnr. Again, that's cnc.link/legalwebnr. And that will show that you were here and that you provided a gift based on what we're doing here today. Your donations, they're powering our legal advocacy, including the upcoming launch of our Compassion Legal website. Keep an eye on your inboxes for more about Compassion Legal over the next month or so, and for the recording of this webinar. Thank you all again for joining us today. We appreciate your time. And for everyone at Compassionate Choices and our panel, we hope you have a great rest of your day. Thank you so much.
Thank you.